Okay, you have the, okay. So, Rob's here, Duncan, to speak about municipal bonusing, and before Rob speaks, I just want to pass this motion out, or put this motion out, or it's not a motion, but we want to pass out the information. Just a little bit of preamble, I guess, Rob, before you speak. One is that the purpose, I guess, behind here, and as you insinuated or are going to insinuate that there's municipal bonusing that's potentially going on, we have a position from our legal that certainly states otherwise. I'd like to have a copy of that passed out. It's available for those to the public as well. And I think that, I'm certainly prepared to hear what you have to say, as would be counsel. But I'm not in any position to have a debate whether our legal position is correct, or our staff's position is correct, or your position is correct, because that's not what we're here for today. So I hope you can appreciate that. And I understand that you need a little more time. I think you can see, based on just the previous group that was here, we're not so regimented that we hold everybody to the exact 10 minutes. It's our intent to try to follow that rule. That is the bylaw established. That being said, so long as the conversation and information is moving in the right direction, then I don't see any real issue as far as myself is concerned, but I'll leave it as a preview of council. If it's heading in a different direction, then we'll likely probably put an end to it, simply because it's not serving the benefit of the purpose of why we're here today. So. If you want to pass that along?
I want to confirm that.
Of not,
Because it was enclosed, it's an enclosed document, so you need to have it.
oh, so you need this.
We need that, but we also need to make sure that they're comfortable with dealing with this solicitor letter in open session instead of closed.
Okay. So do we actually need this, or do we?
He's requested an additional 10 minutes. So
So you
Okay.
say a maximum of 15 minutes?
you want to put a cap on it? That's up to.
So it's
Okay.
for 15, and
So I need a mover and a seconder that the time limit for delegates outlined in section 19.3.4 of the procedural bylaw be extended to permit Rob an additional 5 minutes to speak. Do I have a mover? Councillor Lawrence, seconded Councillor Scher. All those in favor? Opposed? Was there an opposition? I didn't see your hand.
You want to take the vote again? No. I'm
Sorry.
in favor, sorry.
Okay, I didn't see your hand.
I was reading.
I didn't see your hand go.
Because it didn't.
Okay, so that's carried.
make that 5.
Okay, and just through confirmation, not a vote? Or we
No,
need a
just
vote?
confirmation's fine.
So through confirmation of council, you all have a report from our legal. So long as there's nobody concerned about having that report made public, then we'll ask the clerk to make that available.
Yeah,
Everybody's fine with that?
I am.
Okay? So you don't need a motion for that?
No.
Okay. Okay, Rob, you have the floor.
Thank you. I have
This up
some,
for you. 1 second. That's your copy of
great,
that.
thank you.
So you'll have to use
Yes,
arrows to go back and
yes.
forth.
Thank you.
Okay.
It's a little easier here. Okay, yeah. All right. Okay, so the biggest problem I was having on this particular subject was explaining what municipal bonusing actually is. The easiest way to explain it from my perspective is the use of public funds to assist anything that's private. So in that context, if you look at the subsection 2 of this is from Economic Development Services from the Municipal Act, starting at section 106. Actually, I may as well just read it because you've given me the time, thanks. The first two words are assistance prohibited. To prohibit is to forbid. So any of the following activities I would consider municipal bonusing. So lending any property of a municipality, including money, the giving or lending, guaranteeing borrowing, leasing or selling any property of a municipality at below fair market value, or giving a total exemption or partial exemption from any levy, charge, or fee. Now, there is an exception to that, and that follows at the bottom there. It's Section 28 of the Planning Act, subsection 6 and 7. 7.2 does not apply because that's for multiple upper and lower tier governments. So let's go to the next one. So from the Planning Act, and this is directly from the Planning Act, I've copied this, deals with community improvement. Since the Planning Act itself deals with issues of land use, community improvement has to be taken into that context. So here they're talking about planning, replanning, design, redesign, re-subdivision, clearance, redevelopment, construction, and so on. And then when you go down to the very bottom, community improvement area means a municipality or an area within a municipality, the community improvement of which, in the opinion of council, is desirable because of age, dilapidation, overcrowding, faulty arrangement, unsuitability of buildings, or for any environmental, social, or economic development reason. So in that context, I'm going to be showing some examples that I don't feel meet the community improvement aspect of land use. So for example, a kitchen is a kitchen regardless of whether it has granite countertops or stainless steel appliances. So one kitchen might be an improvement over another, but from a use perspective, they'd be exactly the same. Okay, so the next part, subsections 6 and 7, and I put them up here, are the powers of council, which allow the giving of bonuses and grants, which is illegal under Section 106, but only in that context of Section 28 of the Planning Act. And then the giving of loans and grants, that is allowed. When you get to the bottom, though, 7.1, the eligible costs, these are the only things that money can be given for. So that's costs, covering the costs of things like an environmental site assessment, environmental remediation, development, redevelopment, construction and reconstruction of lands and buildings for rehabilitation purposes or for the provision of energy efficient uses. So I tend to look at the Act in the narrowest possible terms. I realize that some on staff might look at it in a broader context, and no, I have not read the legal opinion. I just got that now, so I'll look through that later. Okay, so in the county's official plan, this is page 108, and it straddles to 109, it mentions brownfield and grayfield redevelopment and the use of community improvement areas, specifically the use of a community improvement plans and areas to deal with brownfield and grayfield redevelopment. Won't get too much into that. I'll skip past this. So this is a textbook example. This is a factory in Hamilton that currently employs nobody and doesn't produce anything. So this would be the perfect circumstance for applying a community improvement plan to, where the building itself, and it's hard to tell from that photo, it's actually 3 stories tall. It's absolutely enormous. It would be very difficult to reuse a building like this for any other purpose other than a factory, and actually even most factories wouldn't operate in a space like that. Where there might be contaminated soil and other issues, the cost of tearing it down and redeveloping the property would be excessive, and that is what I believe the intention of Section 28 of the Planning Act was intended to deal with, situations where you have abandoned buildings or other structures that are themselves an impediment to alternate use. So in this particular case, for example, if you wanted to, or say, for example, say a church wanted to establish a homeless shelter, a soup kitchen, a food bank, anything like that, reuse of that space would be allowed, and the use of public funds to assist it could be applied for a situation like that. If anyone could come forward with an idea on how to reuse the space, then it could be done. So I'm going to move away from that. If you have any questions, I hope you'll ask them. Okay, so yes, I've covered this. Okay, so here's some examples that I questioned, and I know that there might be an embarrassment factor for some of these. The reason I consider some of these to be a municipal bonusing is because they're not in the context of a community improvement plan per se, or with land use. So, for example, I'm not trying to embarrass you, Ken. I know the Caledonia Citizens Alliance you have a certain familiarity with. $450 of public funds were used to cover the phone bill and the website for that particular organization. It's not illegal for you as a private citizen to ask for money. It's only potentially illegal for a council to give it. And I'll get to why that is a little later on. Some other examples. Actually, I'm just going to go back to the very first slide, if you don't mind. So again, the giving and lending of property of a municipality, including money, guaranteeing borrowing, leasing or selling at below fair market value, or giving a total or partial exemption from any levy, charge, or fee. So that's the kinds of things that I'm looking for specifically when I go through council minutes. Okay, so off all that. So the $25,000, get rid of that. $25,000 interest-free loan to the Fisherville Lions Club. Not sure what that was for. Haldimand Motors, in this context, was a development. It had some of its development charges refunded, and I'm sure there are certain situations where that is appropriate to do so. But again, without context, without a full context, to me, it just raises a red flag. The Caledonia Farmers Market in 2009 had $3,420 of its fees waived. None of the other farmers markets, to my knowledge, had any fees waived for that year. The next are a series of community improvement program grants, which were all to private businesses.
Rob, just maybe if I can interrupt, I mean, I can appreciate you going through each one of these examples that you're interpreted in from your perspective. I guess, are you looking for a response? Are you bringing this forward because it's coming from your perspective? And as I mentioned to you before, if you have a reason to think that this should go further, then I would suggest that you take those steps. But to go through each and every one of these examples, I know that we're comfortable to stand on our principles as with staff, that every one of these examples satisfies that smell test that you disagree with. So, in the absence of time, I'd rather you just move along. And if you want to take it further, you're certainly welcome to do that. You have that perspective. But we don't need to go through each and one of these examples because you're challenging them, because frankly, with all of the respect in the world, because you're reading the minutes and you have taken the time to read the Planning Act doesn't mean you're an expert on it. And we do have a number of people who are, and we also have a legal opinion that contradicts what you're saying. So I don't want to get into this back and forth debate as to whether this is a legitimate decision of council 8, 9, 10 years ago, because that's not going to happen here today.
The reason I picked examples from relatively farther in the past is because I'm researching the county chronologically. I'm only in 2011 now. Well,
and again, respectfully, if you feel that there's something that is wrong, then I would urge you to meet with representation or take it with an integrity commissioner, as I mentioned to you before, but this isn't the forum for that. So I'm glad, I understand what you're trying to do, but I'm not sure I understand what you're looking for from being here today, because you're not going to get council to say, well, geez, they are all wrong, and that we are going to change that outcome or change what the advice we've been given from staff along the way, as well as from our legal position. So that's what I'm saying. I don't want to get into this whole debate of contradiction. You're here to make a presentation, but if you're here to educate us on municipal bonusing, with all due respect, Rob, we don't need that. We don't need that from you. You don't have the, I don't respect your position given what you have, because you're taking the time to read it. I can read this. I have staff. I have legal behind us that gives us the advice. We have consultants that come in and give us reports and allow us to write the bylaws that support everything that we've done. So please do not go down that path, because I'll end it.
Well,
That's 4 minutes. 4 more minutes.
this is where, okay, it's clearly, yes, I acknowledge I am not an attorney. I acknowledge that nobody sitting here is either, so that makes none of us legal experts. I'm not here to accuse anybody of anything. All I'm trying to do is point out what I feel are deviations from the rules. So I've showed you the rule, and I'm showing you things that any taxpayer might question. Whether or not you agree with it, I'm not challenging you on your
No,
opinion.
no, and
I'm just bringing this up saying, hey, maybe we should be questioning this sort of thing. Because I did watch Mr. Manley's presentation on the CIP grants and the success, and I appreciate that he thinks that it was, that we're doing a great job. The only question I'm asking is it legal? Now, again, I did not have access to the legal opinion that I just received, and I haven't read it yet, obviously, and I won't in the time limit that I have here. I wanted to point out, this is also from the Municipal Act, this liability of members for diversion of funds. This is the kind of thing that I think every member of council needs to know. When I say read the Municipal Act and the Planning Act, this is the kind of thing that I believe as a member of council you should be reading, because there are sections like this that when you read them, they're actually quite terrifying. You can actually be sued for any money that you distribute if it is not done in accordance with the Act. So that's why I'm trying to bring this to your attention so that you understand that, if some nutball, as you might think, from left field sues you, you just go, well, I don't need to worry about this. If you're disqualified from holding public office and the public has to have an election, then it's a problem. And taking legal advice from staff or anyone who's not qualified to give it is not a good idea. So yes, taxpayers can absolutely take you to task for this, and you've pointed that out, and I appreciate that.
encourage it, Rob.
There's something else I wanted to point out, which is the Dillon Rule. The Dillon Rule covers anything that's not covered by the legislation. Essentially, the only powers a municipal corporation has are those that are expressly given in law. So if you take on a power you don't have, well, you can't do that. So I mentioned in my, actually, and I know you don't want me to focusing on this.
1 minute.
Two of these, the Caledonia Food Bank and the Dunnville Salvation Army in 2011, both received $50,000. Nowhere in the Municipal Act does it say a municipal corporation can give a charitable contribution for that sort of thing. Okay, so, all right, so this, I'll wrap it up. This is what I wanted. I know it sounds like a lot. Personally, I'm not a fan of either the CIP or the CPP programs. I know that staff say they're a success. I question their legality, and I acknowledge that on that we might have to disagree. Two of these bylaws, bylaw 1187-11 and 1192-11, in my opinion, both violate section 23.3 of the Municipal Act, and that's the delegation of authority. Now, I didn't make a slide for that, but what I did print it off before I came here today, and I'll just read things that you...
Mr. Duncan, from a procedural standpoint, we'll have to cut you off. Your time is over.
Adopting community improvement plans that authorize bonusing is not permitted. Thank you.
Thank you, Rob. So I need a mover and a seconder that the presentation from Rob Duncan dated March 26, 19, municipal bonusing be received as information, and that the correspondence from the county solicitor, community improvement provisions grant offers pursuant to the Planning Act be received as information. Mr. Corbett? Seconded. Councillor Metcalf? All those in favor? That's carried unanimously. Thanks, Rob.
Can I ask a question? Or
Sure.
Okay, I just want to ask, Rob, we've had talks and we agree to disagree on this. So I'm not a lawyer, as we've said here, but one thing I did check, like to name a few, Hamilton, Barrie, Waterloo, Oakville, St. Kitts, Timmins, all over the province, they have these, and they have their solicitors and have felt that it's a legal program, and we have not broken any legalities. But you're in disagreement with that?
Yes, particularly in things like business beautification grants, just because, again, I look at the Planning Act as a use, not as an aesthetics thing. For me to say that a grant to the Cayuga Car Wash, for example, it makes it a better, to me, that's not an improvement. You went from an existing business to the same business. In almost every case where I see a CIP grant given, it was for the existing business to essentially make the facade or the appearance of the business more attractive. That I don't see any justification for. And now, again, that's my opinion, and I understand that.
Totally disagree.
you know, I saw the presentation Craig gave this morning, and yes, the pictures are beautiful, but should taxpayers be responsible for funding private enterprise? And I believe wholeheartedly the answer is no.
Anything else? Thanks, Rob.
Okay, thank you.
So through you, Mr. Mayor, we've circulated, when this presentation was brought forward to us and the concerns about bonusing, the CPP program, et cetera, we immediately contacted our legal counsel to get a thorough review of it. We had done that when the programs were originally developed, but in this particular case, we want to ensure that we had that information for you here today. Woody McKeggs has put this together. He's peer-reviewed this, had this information peer-reviewed to ensure that it was encapsulated the legislation and the requirements. He's done a nice job of being able to present it, lay it out in a simple format for a layperson to be able to appreciate the background to the legislation and what provides the county the authority to do this. And so, like many of the cases that Councillor Lawrence raised in other municipalities, no doubt they've done the same thing. So we wanted to make sure that the public and the newspapers had that same information here today in a timely fashion, so that the allegations and concerns being raised by Mr. Duncan could be vetted immediately, so that there would be no doubt in people's mind. The deputy is absolutely correct. I don't believe any lawyers around this table. That's why we hire outside counsel, and we have some of the best outside counsel in the province of Ontario. And so you have that report. The public has the report, and we will post that on the web as well, just for information's sakes, in case anybody has any further questions with respect to it.
Okay. Any other questions to staff? No? I do think it does speak, the legal opinion does speak for itself, but I do think it's important that that council does listen. You're not on the,
I know I'm not on the agenda, Mr. Chairman. I just wanted to make one comment.
but you understand the procedural
understand
bylaw
the
better than
procedural
anyone.
bylaw.
So there's no,
I know I'm out of order, Mr. Chairman.
So-
I understand that, but I want to just leave you with this one thing. The procedural bylaw, just for information for council, the procedural bylaw is set up to protect the speaker. Mr. Mayor, I watched it all. You interrupted him. He never got a chance to finish. and you-
okay, so I'm going to interrupt you too.
I know, that's
Thanks.
fine. I understand.
Have a good day. So, I just want to leave it with that, that my confidence behind the staff that sit here, that work here day in, day out, the consultants that continue to be brought in to support these types of initiatives, to see the report that came back here from our economic development team speaks loudly and speaks all the words that need to be spoken. And yeah, my frustration shows when someone decides to want to come in today and contradict that, because I don't think that's the appropriate way of doing business here. And I think there could have been another way for us to achieve the same outcome. Everybody is entitled to opinion, as the previous lady mentioned. Yes, the procedural bylaws are here, and we're here to protect not just the public and their interests, but also their financial interests as well. And I think that we do over and above and beyond to ensure that that happens. And so I do get somewhat frustrated when we're being challenged by that, because I don't believe that that is the case. And I would encourage and certainly suggest to anyone who feels otherwise that they follow the legal procedures to determine another opinion, because what's happened here in the past, we've vetted all of those programs, the CIP program, which I've seen tremendous results. We've vetted the front-end financing program, which I've seen tremendous results, and we're seeing growth. We talked about the opportunities and growth that's happened in Haldimand County as a result of that. and we're seeing things happen. We're having different groups on a social services perspective coming in on a regular basis, asking for support and how we can support them and how we can better provide different social housing, different units for those people and individuals. And where we can support them and find that, I think it's incumbent upon us. And so all of those fall into these types of programs. And so, yes, there's some black and white inside the act, but there's also a number of programs that fall there to support the initiatives that we've done. So I stand behind them. I know the previous counselors that have been here stand behind them, and I certainly stand behind staff. And Craig, I commend you and your team for everything you've done. And I'm sorry, Rob, that I just can't be on the same page with you on this one, but you know, that doesn't mean that, that we have to agree or disagree on everything, so. Okay? Our third individual is Rocco Olivero, RKO Enterprises, Inc., request to waive development charges on affordable housing complex. It's page 232. I'm sure you're going to find your presentation a little challenging right now.
Well, I didn't come